So you have a workers' comp hearing and it involves a treatment request. How does your attorney prepare for that? Well, this is how I would prepare for it. So first of all, I want to determine what is the treatment being requested. Is it like chiro or physical therapy? Is it a diagnostic like an MRI, X-ray? Or is it more like a specialized diagnostic like an EMG, something like that? Is it like a back injection? Is it a surgical procedure like a rotator cuff repair? And these things are important. And then I need to see what are the allowed conditions in the claim. So is it a soft tissue type condition like a sprain strain, or is it a more significant thing like a herniated disc or a meniscal tear in the knee or whatever? Because the reason why that's important in this analysis is because if the treatment that's being requested is, for example, like a surgery or an injection of the lower back, but the only thing allowed in the claim is like a lumbar strain or sprain, then that's a soft tissue condition. That's not going to open the door for the injection or surgery. So then you would have to get a more significant condition allowed in the claim. Now, if the claim's allowed for like a herniated disc at L5S1, that might give entree to surgery. But if it's not, like if it's a sprain strain, it won't. On the other hand, if it's a sprain strain, but what's being requested is chiro or diagnostic, like an MRI or X-ray, that might be enough. And many times, if you have a lower back sprain strain and your doctor is requesting an MRI and you've never had an MRI of the lower back in this claim, then a lot of times those things get authorized just as a matter of course. Now, the third thing I'm going to look at is what's the medical support we have. So if it's just like a lower level thing, like a chiro or a diagnostic, that's a less requirement. I need less evidence for that. I need less support. Maybe I just need a C9. Maybe that's good enough. The C9 is a request for treatment. But otherwise, I will look, a lot of times as a workers' comp attorney, I'm looking at the contemporaneous medical. And I'm going to do that for whether it's chiro or surgery, I'm going to look at contemporaneous medical. And what do I mean by that is, so if your surgeon or your chiro or whatever, as your chiro, I request a course of chiropractic treatment. And I saw you on April 5th, and then I submit a C9 on April 7th requesting 12 chiropractic visits, adjustments, whatever. And that's the C9. I'm going to look at what did I write in my April 5th, what are in those April 5th chiropractic notes that substantiate the necessity for that chiro treatment. Likewise, if it's a surgeon and the surgeon's requesting, it's a knee surgeon and he's requesting a meniscal tear, what did that knee surgeon, and I'm assuming it's allowed for meniscal tear type condition, what did the surgeon write in that let's say April 5th you went to the knee surgeon and he submitted a C9 on April 6th. What did he write in that April 5th note that substantiates the necessity for that knee surgery? So I'm going to look at that. So I'm going to look at these things, and if I don't have, like if your doctor's requesting a knee surgery, and it's kind of cursory the reason why he needs it. He's just like, oh, he's got a tear, knee surgery, and he is not really connecting the dots. I might reach out to that knee surgeon. I might say, doctor, can you just give me like a couple sentences or a paragraph or whatever explaining why that particular procedure is necessary for this this condition, and hopefully that surgeon will say, yes, I will. Sometimes they'll charge us for that, but hopefully he'll give us something back that's useful. And likewise, even if it's just chiro or something, sometimes if it's a soft tissue and you've already had a course of chiro and your chiro is asking for another course, well, a lot of times, just as out of the box, a lot of hearing officers, the paradigm is, well, if you get injured and it's allowed for soft tissue, you should have a diagnostic, you should have physical therapy, you should have a chiro treatment, whatever, chiro or PT. But it's kind of like, well, you've had your course of PT or chiro, why do you need another course of PT or chiro? So if that's the case, we might go to your occupational med doctor or the chiro and say, hey, can you give us a reason why this is necessary? Because this person's already gone through a course of PT and physical therapy. Why do you need more? right? Why is this necessary for this injured worker? And hopefully they'll help us by providing some kind of statement. If they don't, then, that's not going to be the greatest thing for the hearing, but we still might have enough with the medical that we have to go forward. So when we go to the hearing, we're gonna talk. One, we have to match the treatment to the allowed conditions, and then we have to use the medical support that we have, the contemporaneous medical, the explanations by the doctor. We're gonna argue, hey, this is why this is needed for this injured worker. And we might say, injured worker, do you want this thing? And you might say yes, and I wanna get back to work, or this chiro treatment, for example, it allows me to continue working, and I prefer to do the chiro versus taking narcotic medication, what have you. We're going to look at the facts and the situation. We're going to try to create some kind of argument that makes sense and that's persuasive. That's why you hire an attorney. So what's going to happen as a hearing officer, and remember, it's hearing officer lottery. It's hearing officer, getting hearing officer X might be more reasonable than hearing officer Y, and we don't get to choose. But you're going to have a DHO hearing officer, and if the hearing officer of the DHO, the district hearing, denies that treatment, we're going to appeal that. We're going to have a second hearing at the SHO. Now, if the SHO denies it, then you can request a third level appeal, and you can put forth a request for reconsideration before the full commission. But there's got to be something really unique in order for those, either the third level appeal or the request for recon, to go forward. Now, the other thing that you could do is so a request for treatment is an extended disability issue. So extended disability issues, you could file a mandamus to the 10th district, but it's unlikely that your attorney is going to do so. And it's not because your attorney doesn't want to file it to the 10th district because whatever, it's extra work. It's because it's futile. And why would it be futile to file a treatment request to the 10th district? Because the standard that the 10th district is going to look at to evaluate whether or not this the hearing officer's decision of the industrial commission was, whether or not it's an abuse of discretion. And if there's an abuse of discretion, then they could say that the hearing officer abused of discretion, overturn the decision. Is they're going to say, did the hearing officer rely on some evidence? It's the some evidence standard, and 99.9% of the time, there's going to be some evidence, and all the hearing officer has to say is, I relied on this, doctor's report, this contrary doctor, this Medco 21, this file review. And if that file review is in the claim file and there's nothing overtly insane about that file review, which there wouldn't be 99.9% of the time, then that's some evidence within which the hearing officer can rely upon. They don't have to explain why they relied upon that evidence. They just have to say, I relied on that report for my decision to deny this treatment. And that's why you don't file these treatment requests to the 10th district. Really, what you need to do is you need to win at the administrative level. And that's why you get an attorney involved. They kind of try to build the strongest foundation to win. Now, here's the thing. Because of that, if it's denied, the question might be like, well, can I refile that treatment request? Can I wait a month and then refile? Well, your doctor can request it, but the industrial commission has already ruled on it, and there's really no new or changed circumstances. And if there's no new or changed circumstances, then they're just going to deny it. Now, let's say you went, for whatever bizarro reason, your doctor requested surgery, and at the time that it went forward before the hearing, the district and staff hearing officer, your claim was only allowed for a lumbar strain. Well, I'm assuming you're not represented, because no attorney would go forward with a surgical request where there's only a soft tissue condition allowed, unless there's some greater strategy involved. And the greater strategy might be that maybe it's a timing thing. Maybe there was a herniated disc that's pending that was likely to be allowed, and it just so happened that it ended up going forward before the herniated disc was ultimately allowed. But what new and changed circumstances might be is that it was denied at the time. It was denied because of soft tissue. You know, it was only allowed for a lumbar sprain strain. But now your claim is allowed for a herniated disc at L5S1, and so now that's new and changed circumstances. What is the new and changed circumstances? Well, before it was only allowed for soft tissue, now it's allowed for a disc, new and changed circumstance. So that might get you back in the door, and then if your doctor re-requested the herniated, you know, the surgical procedure, then it might be allowed under that circumstances. But otherwise, if nothing else changes, your doctor can request the treatment a billion times, and a billion times it's going to be, you know, denied because it was already denied in the past and nothing has changed. So that's a treatment request. And this is one of these situations, you know, I always, in these workers' comp videos, I always recommend that you folks get a workers' comp attorney involved. And certainly if treatment's being denied, at that point, you really should get a workers' comp. Frankly, I think most people should get workers' comp attorney involved from the jump, unless things are going well and, you know, whatever. But I think if there's any kind of controversy, if there's any kind of headwinds that you're running up against, that you should get a workers' comp attorney involved. And at the very least, you should consult with a workers' comp attorney or a few. And they may very well say, hey, you don't really need a workers' comp attorney at this time, or, you know, maybe you're going to need a workers' comp attorney, you know, later down the road, but now you're okay. But at the very least, if you have a treatment denial and you have something going forward before the Industrial Commission, you should get a workers' comp attorney involved at that point, because again, this is a situation where if you go through the door and you've passed the Rubicon, you can't go back unless something changes, the new or changed circumstances. So you might be setting yourself up for a situation where you can't undo the mistake that you made at the Industrial Commission. So that's why I recommend you get an attorney involved. If there's anything, particularly treatment requests, additional condition requests, whatever, you definitely want a workers' comp attorney involved in your case. So, as I said at the end of all these videos, ask your neighbors, coworkers, rabbi, imam, priest, preacher, whatever, friend, coworker, who do they use, who do they recommend, and go with that person. Otherwise, go search on Google for workers' comp attorney. Talk to as many workers' comp attorneys as you need to find one that you get along with, because you're hitching your wagon to that attorney. You want to get the one that you're going to stick with. But you do need somebody involved. Otherwise, folks, stay safe. Don't get workers' comp attorney, or don't get workers' comp injuries. Don't get injured if you can at all help it. But do get a workers' comp attorney if you have any kind of complicated situation, and at the very least consult with one. But I want you to stay safe. I do appreciate you sticking with this video and watching the other ones. And this has been a workers' comp hearing involving a treatment request. Okay, thank you.